Your SaaS is built, the launch button is right there, and then your first big customer's lawyer drops a checklist demanding documents you've never even heard of. Let's make sure that's never you. First, a disclaimer. This video is for informational purposes only and does not constitute legal advice. Consult our team or another qualified professional for personalized guidance. Hey everyone, Robert here, legal consultant, licensed tax advisor, and registered trademark and design representative. At Chiroptera Consulting, we help SaaS founders get the boring paperwork right, so it never blows up the fun part. Because here's the truth, the code is the exciting bit, but a handful of documents quietly decide whether you get sued, get funded, or get acquired. So today, the documents you need before the launch, not after a deal stalls. One rule before we start. Your documents have to match where your users are, not just where you're incorporated. A US template does not cover your European and Californian users. With that out of the way, let's build the stack. Tier 1. The free documents every single SaaS needs. Live on your site from day one. First, your terms of service. This is your contract with every user. It sets the rules, caps your liability, handles payment and disputes, and lets you remove bad actors. Skip it and your relationship with users runs on whatever the default law says, which is rarely in your favor. Second, your privacy policy. The moment you touch personal data and an email address alone counts, privacy law requires you to tell people what you collect and why. That's GDPR in Europe plus laws like California's CCPA and others. And it has to be honest. It must match what your product actually does, not a copy-pasted template. Third, cookie consent. If you're running analytics or tracking pixels, you need real consent before they fire. And yes, we got a whole video about that one. Tier 2. If you sell to other businesses, these are the documents that close deals. And here's the big one founders Google. Do I need a DPA, a data processing agreement? Almost certainly yes. When you handle personal data on behalf of your business customers, the law makes them the controller and you the processor. And it requires a written contract between you. That contract is the DPA. And no, your AWS or Google Cloud terms do not cover this. That's your DPA with your cloud provider. It says nothing about your customer. Here's the part that stings. When an enterprise buyer's procurement team asks for your DPA and you don't have one ready, the deal just stops. A missing DPA has killed more SaaS deals than almost any product flaw. And while we're here, you also need DPAs with your own sub-processors, your cloud host, your payment processor, your analytics tools. Right next to the DPA, serious B2B customers will want service level agreements, SLAs, your promise on uptime, support, and what happens when something breaks. Enterprise won't sign without it. Tier 3. And almost nobody gets this one right, so listen closely, because it decides whether your company actually owns its own product. Number 1, IP assignment. If you hired a freelancer or an agency to build your code, here's the shock. Your company does not automatically own that code. Without a signed IP assignment, the developer who wrote it may legally own a piece of your product. Same goes for anything a founder built before the company even existed. This stays invisible right up until you raise money or sell, when due diligence asks one brutal question. Do you actually own your IP? If the paperwork isn't there, the deal dies or the price drops. So every founder and every contractor signs an assignment, full stop. Number 2, trademark your name and your logo before a copycat or a troll registers it first. And number 3, protect the code itself. Lock down your trade secrets with confidentiality agreements and watch your open source licenses, because some of them can force you to open up your own code if you're not careful. Don't know where to start? That's exactly what we do. And a bonus for the co-founders watching, get a founder's agreement in place. The teams who skip it because everyone's friendly are exactly the teams who need it when the friendship hits a wall. Lightning recap. Every SaaS needs the public trio: terms of service, privacy policy, cookie consent. Selling to businesses, have a DPA ready before procurement asks, plus an SLA. And remember, your AWS terms don't count as your customer DPA. And the tier that decides if you own your company, IP assignment from everyone who touched the code, a registered trademark, and real protection for your code and secrets. Last thing, match every document to where your users live, not just where you're based. Want your full legal and IP stack built right? So your first enterprise deal sails through instead of stalling, and you actually own what you've built? That's exactly what we do. Book a call with us, link is in the description below. And if this saved you a panic before your big lunch, smash that like button, send it to your co-founder, and subscribe for more straight talk compliance. Thanks for watching, and remember, compliance with the law prevents the flaw. Till next time.